This is the Child Abuse Prevention Council meeting on December 6th, 2024 at 7:30 a.m. Council Member Remus Allen.
Here. Morning.
Council Member Aspiras. Absent. Council Member Barron.
Present.
Council Member Kane.
Here.
Council Member Gallardo.
Here.
Chairperson Gibbons Shapiro.
Here.
Council Member Goodwin.
Here.
Council Member Hasnath. Absent. Council Member Jordan.
Here.
Council Member King.
Here.
Council Member Liu. Absent. Council Member Madia. Absent. Council Member Mengesha.
Here.
Council Member Sra. Council Member Stewart.
Present.
Council Member Sturm.
Present.
Council Member Zeman.
Here.
Are you going to call us?
You have a quorum.
All right, and we also have emeritus members here, Lydia Harris, Penny Blake. We have our advisory members here, Carolyn Robinson. I'm sure I'm missing some other people, and also a member media just arrived. Is there anybody who I forgot, and member Liu just arrived? Is there anyone else that I forgot to call?
Except I'm a citizen advisory member, not emeritus.
I'm sorry, Lydia, an advisory member. All right, so roll call is complete. We're going to move to public comment. I have one public comment card. I see there's a public comment card also in the hopper from Catherine Campbell. So I'm going to call first for, and do we have any public comments online, Madam Clerk?
Yes, we do have public comment.
All right, so we're going to have public comment be 2 minutes each. So let's start with Rocio Abundis. And actually, if you could go to the public comment area. And then if people who have submitted public comment cards could just line up behind Member Abundis for your public comments so we can get them going quickly. That would be great. So 2 minutes, please.
Okay, is the mic on? Yeah, perfect. Good morning. My name is Rocio Abundis, and I'm here on behalf of the Greater Bay Area Partnership Child Abuse Prevention Council. As advocates for children and families, we at the Greater Bay Area Child Abuse Prevention Council are deeply concerned about the harmful effects of developing immigration policies, particularly the proposed expansion of deportation and the public charge rule on the well-being of children and in immigrant families. These policies exacerbate the risks to a child's well-being in profound and far-reaching ways. Deportation policies may result in separating parents from their children and can cause significant trauma. Children who witness or experience the forced removal of a parent often develop anxiety, depression, and other emotional issues that can persist into adulthood. In cases where children are left behind, they may be thrust into the foster care system. The public charge rule, which discourages immigrant families from accessing essential benefits such as health care, housing, and nutrition assistance, is equally concerning. These resources are critical for child development and safety. By creating a chilling effect where families fear seeking help, this policy increases the likelihood of neglect, food insecurity, and unmet medical needs, all key risk factors for child abuse and neglect. We urge policymakers to prioritize the welfare of children when considering immigration policies. Family unity and access to basic needs must be protected to ensure every child has the opportunity to grow up in a safe and nurturing environment. Our children's future and the future of our nation depends on it. Thank you for your consideration, and I'll leave these with the clerk.
Thank you. Do we have any other public comments on agenda item 2? I see that some of the cards I have are for agenda item 4.
So I have an online public comment.
Great. Let's go to...
Benzi, I'm unmuting you. Please accept the unmute. The timer will start when you begin speaking.
Yes, hello, good morning. I mean, we have a really bad problem in family court. And the reason we have this problem is that when abuse comes up, the lawyers want the proceedings to continue. And if the child abuse was properly addressed, lawyers would stop making money. And what happens is the offending parent pays the lawyers whatever they want just to stay out of jail. And the protected parent pays the lawyers just to see the parent, to see the children. And they know that the parents will never give up on trying to protect the children. So the proceedings go on until the children turn 18. I mean, it's happening to my kids. My kids are being sexually abused. I'm coming to you guys, begging you guys for help. There's nobody to help. And you know what? We need to start admitting to ourselves that the system is complicit at best. At worst, it's corrupt. I mean, if you don't give up, I mean, in my case, the DA's office gets involved. I had charges filed against me. I didn't even commit a crime, and the whole goal is to discredit my claims that my children are being sexually abused. James Gibbons Shapiro, you know all about it. I've written you tons of letters, emails. I tried to come to your office to speak to you. You won't even talk to me. I mean, it's just terrible. The same judge who's denying my kids a screening also did the same thing to Ellie Lorenzo's mother. And now Ellie Lorenzo's dead because the judge wouldn't listen to her mother. She begged and begged, said that the dad would kill her, the child. I mean, we need to start being honest here, what's going on. Thank you for your time.
All right, I think that concludes public comment during our general public comment period. We have the consent calendar, which is got one item on it for the minutes for our November 8th meeting. Do I hear a motion to approve the consent calendar? That was from Member Kane. Do I hear a second? Second from Member Jordan. All in favor say aye. Aye. All opposed? Hearing none. Any abstentions? Hearing none. All right, we've approved the consent calendar. All right, we're going to go now to agenda item 4, which is presentations related to family court. I'm going to make just a brief introduction. We're going to go to public comment, and then we have 3 presenters, and I will help organize the timing for those presenters as we go. But as all of you know, we had over the years and certainly over the last few months quite a desire within the Child Abuse Prevention Council both to learn more about how family court addresses allegations of child abuse and also to think about ways that the Child Abuse Prevention Council might be of assistance. So we are having this meeting today to learn more about issues in family court, and I hope that this is the beginning of more conversations that we have and more things that we might be able to do in this area. So I'm going to go next to public comment. I have 2 public comment cards for people in the room. So we'll start with those. It's Catherine Campbell and Robin Yeamans. So if you could be ready to go, and then we'll go to anyone online after that, 2 minutes.
I want to thank the council for having this session focused on family court today. As most of you know, I am a family court survivor. I was in family court, and today we're going to hear some of the first empirical data about family court. And in that data, you'll hear if you report child sexual abuse, the odds of it not being believed skyrockets. If you have a gal or a child, a lawyer for your child, that happens. When my children, after multiple times of disclosing, were finally at a point where they were heard, instead of processing the disclosure, they gave the children a lawyer. And that lawyer helped to silence them even more. That lawyer said to them, the best I can do for you is give you 50% back with your mother, after they had disclosed that their father had sexually abused them. So when you hear these numbers, know there's people behind those numbers today. This is a very important project we're working on for family court, and it does take a lot of courage to understand where we have been and to move forward. So I thank you for listening today, and I want to thank Professor Meier for being here today, and for James for inviting her. So thank you, and I truly hope that this is just the beginning of looking at family court. It seems to be where we ended up before the pandemic with our council, to realize that that was where the gaps were. Thank you.
Thank you. All right. Ms. Yeomans, you have a public comment? You just come right up to the podium, and there's a mic in the podium, so just speak right in front of the podium.
Good morning. I was a graduate of Stanford Law School, and I was a lawyer for 50 years from 1970 to 2020. And I was a family law specialist during a lot of that time. I'm no longer a lawyer, so I can say what I think, and the bar can't throw me out. What determines who wins in the long run in family court? Money. The law says that you should award fees to the low earner. Who's the low earner? The low earner is a woman. And the court simply ignores that. And if you go over to family court and you look, you will see in case after case after case, the man has a lawyer and the woman does not. And the result of that is that his point is presented more effectively time and time again, and so it affects the judge's thinking about things. The court responds, according to one article, 79% of physical child abuse claims are rejected, and 81% of child sexual abuse claims are rejected. And there are studies that show moms don't lie, or at least they lie less than the dads do. When father alleges parental alienation, the rates of moms losing are even higher. A third of the moms alleging abuse lost custody to the abuser. The article describes this pattern as, quote, deeply gendered. Some lawyers tell mom, don't mention the abuse. I know he beats you up. I know. Don't tell the court, because you'll lose more if you do. Well, I never did that. You can't, if you get a good expert and you work really hard and you take all the time and the client has the money to pay for it, you can prevail or get some reasonable result out of the case.
All right. Thank you very much. That's the time for public comment.
That's it?
Yeah. Do we have any public commenters online?
Yes, we do.
All right.
Benzi, I'm unmuting you. Please accept the unmute. Your timer will start when you begin speaking.
Yes, I mean, when I say that there's nobody to help, there really is nobody to help. I mean, there was one person who was willing to help me, only one, and that was Deputy District Attorney Daniel Chung. And 2 weeks after I begged and begged to help, and he indicated that he would help, he got fired. And now we're paying even more money for that, because he's sued the county, and the county has paid hundreds of thousands of dollars for him to sit at home, and we're paying a private attorney to represent the district attorney's office. I mean, it's just terrible what's going on. I mean, and these people who are sex trafficking my kids, namely Valerie Houghton, she's joking that pedophilia is not a crime, and that the politician, I don't know who she's referring to, I'm assuming the district attorney, is not going to prosecute. I mean, and she's able to do whatever she wants. I mean, I'm being assaulted because of all this, and there's nobody cares. I mean, this is why I'm being prosecuted. She's assaulting me, and I mean, like, this is like unheard of. I mean, it's just terrible what's going on in this county. I mean, I'm at a loss here. I'm begging you guys for just a screening. I'm not asking for a kidney or $1 million. I'm not asking for nothing. I'm asking for a screening, and you guys can't help me get a screening. I mean, I don't know if there's even a point to this meeting. I think it's pointless. I mean, nothing's going to change. I hope it does. I'm going to keep speaking. Thank you for your time.
All right, do we have any other public commenters online?
Yes, we do. Deborah, I'm unmuting you. Please accept the unmute.
Good morning. There seems to be a big breakage between the legislature and the judicial law. I'm part of the confidentiality address program for domestic violence survivors. My daughter and I have been in the family court system now for over 10 years. My latest great disappointment was my daughter's order protection, which was granted by a judge, active for 7 months, to be contested by the perpetrator who hired a fancy lawyer. And as a single mom, I cannot afford to pay for a fancy lawyer. In any hope, the order protection was quashed, and not also was I, as a victim mom, lost for words for what my daughter went through in this sexual traumatic experience, but the judge awarded attorney fees to be paid to the perpetrator by the victim's mom. I am currently in the courts of appeal, appealing attorney fees on a quashed order protection that was obtained on behalf of me, the mom, to my minor daughter. After $350,000 in family court, I can thank family court that I'm on food stamps, I'm on welfare and Medicaid. While I'm eating tough ramen and being in line at the food banks, all the judges and all the lawyers that collected all this money are driving Teslas and BMWs. Tell me where this is fair. As a domestic violence survivor with a history of being part of the address confidentiality program, there's something very broken in the system. We need to be part of the legislature. If the legislature accepts address confidentiality program for domestic violence victims, why can't the judge and family court also abide by the rules of the titles to protect domestic violence victims and give domestic violence victims the credibility that they need to be deserved? This is not a made-up story. If one system alleges and says that there is no domestic violence and another one does, there's definitely a broken system, and we need to repair it. Thank you.
Are there any other public comments online, Madam Clerk?
Yes.
How many more do we have online?
2 more.
All right, go ahead.
Mara Lee, please accept the unmute. You may begin speaking.
Yes, hello. My name is Mara Lee McLean. Can you hear me?
Yes.
Yes, I'm actually speaking nationally, and I just want to bring the attention to this, that this is a national crisis, and women, mostly protective women that are trying to protect their children when there's been sexual abuse, are losing custody in a rapid rate. I've been doing this for 30 years. I'm an author and a national speaker, and I just want to bring attention to you all there that this is a criminal behavior going on, and it's out of control. Thousands and thousands of cases. Over the 30 years I've been in this, I literally have thousands of cases all across the United States. This is damaging to our children for a lifetime, and the women that are trying to protect their children are ruined, just like this mother that just spoke. So I just wanted to bring that forward and let you know, absolutely family court reform, get these attorneys trained, these judges trained, CFIs, PREs, and make sure we start making a difference, because we're losing lots of children and lots of educated, good, loving, protecting moms. That's all I have to say. Thank you so much.
Thank you. And we have one more online, and I just received 2 more in the room, but let's go to our last online public comment.
Mama, please accept the unmute.
Thank you. Hello. I think we need to quantify the problem. I have been through family court in England and in the US, and it is a problem worldwide. But in America, $58 billion runs through the family court system every year, which is more than all of the other courts put together. And 58,000 children are forced into to live with their abusers. From my own personal experiences, I can tell you very clearly there is an intent to silence children. And at every level, they are silenced through whether it's the school, agencies, or right up to the legal representatives, the custody evaluators, the minors' councils, the family therapists. There is a syndicate which is operating, which where people are paid to lie and traumatize children. And I think we are failing to understand the long-term effects of the level of betrayal trauma and institutional trauma that these children are experiencing, because they are taught from a very young age to stand up to bullies, but when they are children and the bullies are their parents, nobody stands up to the bullies. Quite often the parent who is claiming the protective parent is abusive is financially wealthy or powerful or connected, and quite simply in those cases the protective parent and the abused children don't stand a chance. It's not necessarily gender specific. I think, again, as the lady mentioned earlier, it is very much more centred on who has the most money in family court, because they're the people that win. They're the people that can hire attorneys, and they're the people that can peddle lies for an awful lot of money. So you can't get a resolution when somebody just wants to win. So thank you for your time. I'd like to see some changes made, and we appreciate you giving Joan a platform. Professor Joan.
All right, we have two more in the room. Maria and Alicia, if you could both come forward, and we'll start with whichever of you comes to the podium first.
Do I need to pick up the mic?
You don't. We're hearing you great.
Okay, good morning. I'm Maria Duncan. This is my daughter, Alicia Johnson. I've been a resident of Santa Clara County since 1962. I'm a graduate at Stanford University, both undergrad and graduate school of business. I've been involved with family court since about 1995, first as a litigant, then as an advocate for change, activist, and then also afterwards as a family court paralegal. I am a co-founder of an organization called the National Coalition of Family Justice for California. We're no longer operating, but it was 3 moms who got together with the assistance of attorneys to address family court abuses. We would picket every Monday for 2 years. And then we also hired an investigative journalist to look into family court issues. Particularly issues of domestic violence and child abuse were very prevalent in the cases of people that we spoke with. We tried to make a change, and after all that picketing, Judge Jack Kumar, put together a task force in order to address these issues. A protocol for change was issued with a lot of the recommendations that we as a group made. And we didn't collect any money. We were completely volunteers. It's very demoralizing to know that here 20-some years later, the same systemic issues are in family court. I believe that what really needs to happen is there needs to be better training not only of the judges, but the court personnel and any adjunct personnel that's also involved with family court. In my case, I lost custody of this beautiful young woman because a white psychologist came to court and opined that because my skin color, I'm African American, but I'm very light skinned, she opined that my daughter would become confused about her racial identity if she didn't live with her father, who, by the way, was a convicted batterer. And so she's got her own story she's going to tell.
All right. Ms. Johnson, go ahead.
I want to start off by saying that I'm so grateful to be here, because most of the kids that I grew up with who survived what I survived did not make it to this point. And what I mean when I say that is they did not make it to a point where they could actually function as an adult. They didn't make it to a point where they could graduate high school, let alone go to a private university, which is what I ended up doing for myself through massive amounts of healing and inner work. And they definitely didn't get to a point where they could speak their truth and speak from a place of conviction, a place of confidence, and a place of sovereignty over their own life and their own body. I'm speaking to you from a very different space than I would be speaking to you from the girl that survived so much. And if you care about our future and the children of our future, you need to listen to them. I would need about 2 hours to go into the horrific impacts and effects that I have survived and transmuted to a point where my life and my purpose and my mission is to help other survivors. And I've been fortunate enough to do that behind the scenes for 15 years. Thousands of people all over the world, globally, that I've personally worked with, that I have seen behind the scenes who don't even know how to communicate what happened to them because it's so jarring. And as someone who is in my 30s now, I know that there's parts of this that will never heal.
Thank you very much.
To do the right thing.
And I want to thank all the people who made public comment today, both in the room and online. I think it shows not only the strength of emotion over these issues, but also the need for our council to be looking at them today. Alexis, I know I said I was going to have you go first, but is it okay if I go instead to Professor Meier, since she's zooming in from across the country? All right, thank you. We're going to start with Professor Joan Meier, who is one of the foremost researchers on family court and child abuse allegations in the country, and we're so lucky to have her presenting here today. She's going to talk for about 20 minutes about her research findings, and then we're going to have a few minutes for clarifying questions, but I want to try to get to our two other speakers today as well. So I see Professor Meier's slides are on the screen, so Professor Meier, take it away.
Okay, thank you so much, James. Can I be heard?
Yes, we can hear you great. Thank you.
Great. I'm almost speechless after listening to the last remarks as well as all of the other remarks, and I just want to say there's a lot that needs to be discussed about why this is happening in family courts and what the fixes could be. I don't think it's a simple matter of training, although we have to be doing that as well. But so I've been asked to present my data, some of which was already presented by Robin Yeamans, but I will tell you more about this study and why it happened. A bunch of years ago, I had been working in a nonprofit I founded called DV Leap, which was focused on appellate advocacy. And I had hoped not to specialize in custody because custody is so traumatizing and vicariously traumatizing. But there was no choice. We were inundated with custody cases involving abuse. A big part of that was the claim of parental alienation, which I can talk more about, but is not the center of this presentation. And we saw, it appeared that child abuse allegations were really the worst for women in terms of outcomes. I decided that there really wasn't, sorry, I'm going to go back. There wasn't really, we were having trouble getting attention from the courts and from court personnel and from the media on this problem. People thought it was a one-off here, a one-off there, and I decided we really need data. Let me just give you this example. This is one of thousands I could be giving you. It's a case from back in 2006 in Arkansas, and this just sort of shows how this works, the silencing of children's fears and realistic fears. This is a custody evaluator who asked the child, what is your biggest worry? A great question when you're assessing a child's situation. Open question. The child comes up with, my biggest worry is my father killing me and saying my mother did it, which I thought was a brilliant encapsulation of what it's like to live in a domestic violence home where you know you are a pawn and you know that the agenda is to hurt the mother, even though you're a kid. What does the evaluator do with that? It says that their boy's negativity toward his father is unnatural and abnormal, and recasts it as a form of parental alienation, which is a junk science theory that is used to deny abuse as well as other things, and thereby got the court to award custody of 3 young boys to the abusive father. This is how it works. There's junk science. There's a lot of ways that children's honest and realistic fears and experiences are just denied and reframed and suppressed. So here, getting to the study itself, it was a great team effort. It was a bunch of social scientists and me. Sean Dixon was really the sine qua non. He had both the legal training and the statistical, and we couldn't have done it without him. What did we do? We wanted to get national data, and there had only been a few studies prior to this. They were all very state-based or even smaller, And you couldn't tell from these studies what the big picture was at all, and I was determined to get a national picture. And the only way to do that was to use electronically published opinions, which luckily by the time we started this study, they existed. So we went back over this 10-year period. We defined the scope of it to look at all what we call private custody, meaning parent versus parent cases, not involving state actors. All cases involving abuse or alienation claims. We got way more cases in that comprehensive search than we expected. We did not do a sample. We did all the cases that were relevant. And we narrowed the scope of we narrowed down to about 4,000. We were coding for hundreds of things. We have still not analyzed everything that we coded for. But I'm going to give you some of the highlights. First, I'm going to talk about what we found about the rates at which courts believe or credit abuse claims, especially by mothers, and the rates at which they take custody away from mothers who are alleging abuse. And then a few gender comments and observations, and very briefly, some of what we've seen when there have been guardians ad litem or evaluators in the case. They're supposed to be neutrals, they're supposed to be focused on the best interest of the child, and they get enormous deference, almost greater than the judge, in terms of the court process, and yet they seem to be terribly biased against mothers' allegations of abuse. Okay, so moving into number one. How often do courts reject mothers' abuse claims? On average, 64% of the time. When it's DV, it's closer to half, but when it's child physical and child sexual, as Robin, I think, reported, 79% of child physical abuse claims were rejected across thousands of cases we were looking at, and 81% of child sexual abuse claims were rejected. Averaging out, when you just talk about child abuse, to 80% of child abuse claims by mothers were rejected, were just not accepted by courts. A brief comparison to what we know otherwise about children's abuse claims. There have been a couple big studies, one in particular, two, I guess, in Canada and the US found generally that the vast majority of child abuse claims, even in custody litigation, were considered in these studies, these were objective evaluators or child welfare personnel, they considered them to be good faith and a majority of them to be likely valid. Generally speaking, this is obviously generalizing a bunch of studies. Roughly a third were found uncertain, but very few were considered to be intentional lies. So you're talking about independent research that had nothing to do with anyone's agenda. People were just looking at this to find out if it was true that there were a lot of lies about child abuse in family court, and they found the opposite. Okay. What our data showed then, compared to roughly 2/3 being credible, what our data showed was that the odds of courts believing abuse claims were far lower when it was child physical abuse. So they were 2.8% less likely to be believed than when the claim was adult partner violence. This is a comparison of how credible courts are treating child abuse and adult abuse claims. A lot less likely to be believed if it's physical, and even less likely to be believed, 3.1% less likely to be believed when it's sexual abuse in comparison to when it's partner abuse. So that tells you, in particular for this commission, it tells you that child abuse in particular is a huge problem in family court. I'm not saying domestic violence isn't a problem in terms of courts' responses, but the bias against it is huge when it comes to child abuse. Okay, so there's a lot of non-belief. So what is happening in terms of mothers retaining or losing custody? Let me be very clear on how we defined custody loss. It was our definition. We basically said if the mom started out having the kids in her primary possession, and then the court awarded the kids to the father, that we called that a custody loss. I can explain that more later, but it seemed to me the layperson's logical, if you're a litigant and you go to court and you're the primary parent for your kids and you walk out without your kids, I think that's a custody loss. That seems to me the right definition. It did narrow the number of cases we could look at because a lot of the opinions we were studying didn't say who started with the kids, and we didn't count those, obviously. But just looking at the ones where we could say, yeah, mom started with the kids, dad ended up getting custody, what did we find? That about a quarter of the time, if a mother's alleging abuse, they're going to lose custody. But if they're alleging child abuse, it's closer to a third of the time, about 33% of the time. I don't know why, in this case, child physical, the rates are higher than child sexual. Usually, in everything we see, as I think one of the speakers pointed out, I think it was Marilee, child sexual abuse is the kind of lightning rod that causes courts to be really punitive to mothers. But in any case, both of them, roughly 33% of the time, if you allege child abuse, you're going to lose custody. Okay. Again, in terms of comparing what happens when a mother's alleging child abuse versus partner abuse, what are the odds, different odds of losing custody? When mothers allege any kind of child abuse, they have 1.7 times greater odds of losing custody than when they allege partner abuse. I'm not sure that we care that much about this comparison, but to me it puts a point on how radioactive child abuse claims are in family court. And we also found, and this is something that's been ignored a fair bit, that even when courts confirmed abuse, they found that the father had committed some kind of child abuse or partner violence. 13% of the time, which was 62 cases, those abusers got custody. None of these were child sexual abuse, which is the good news in the study. But that's a fair number of known abusers getting custody. Hidden in that statistic is the probability, and I haven't done the analysis yet, that those mothers who lost custody had been found to be committing parental alienation, and parental alienation is the scarlet A that causes you to lose custody. But I can't say that statistically yet. Okay, so what did we find out in terms of gender? First, we did these odds ratios, which, by the way, these odds ratios can only be used when the data are statistically significant. So these are all statistically significant findings. We found that mothers' odds of losing custody are 3 times greater than fathers when either parent accuses the other of any type of abuse. So when fathers accused mothers of abuse, they were not losing custody anywhere near as often as mothers were when they accused fathers. We found that mothers' odds of losing custody are even more, 4.2 times higher than fathers, when the allegation is child abuse by one parent against the other. And as I said, 13% of the time, even when courts have found that the father committed some kind of abuse, 13% of the time they got custody, but when it comes to mothers who were found to have committed some abuse, only 2 out of 51, or 4%, got custody. So there's a lot of evidence of significant gender difference. I would call it gender bias, but it's a slightly sophisticated gender bias analysis, because you can't just say, oh, they ruled against her because she's a woman. You have to look at the data and how the abuse claims shake out. Okay, moving to the third point. Mothers' odds. So what happens when a court appoints a guardian ad litem who's a neutral professional? In most states, I'm assuming in California they have to be a lawyer, maybe not. They are given enormous trust and clout in these cases because they're seen as objective outsiders who don't have a dog in the fight, yet they have very systematic bias against mothers who allege abuse, because what we found was that the odds of losing custody, if you're a mom, are 3 to 5 times greater if a GAL is in the case. And that 3 to 5 has to do with different types of allegations of abuse. We also found the same thing, a little worse, with a custody evaluator in the case, 2.5 to 6.5, again, depending on which types of allegations you're looking at. We were able to compare that to fathers who make comparable allegations against mothers. No effect of these professionals on fathers' rates of losing custody. I'm so sorry about my cough.
It's okay. Do you need to take a brief break, or are you okay to continue?
I think I can continue.
Okay.
I'll do my best.
All right. Thank you.
Net effect being that obviously if they're hurting mothers but not fathers, they're significantly increasing the gender differential. So that's it. That's the very quick overview. And I want to talk about some of the limitations. important point, and one that a lot of fathers' rights people are harping on, is that our findings do not say the courts were wrong. We can't say they were wrong. We don't know the facts. We can't second guess the facts. All we're saying is this is what they're doing when these are the allegations. So maybe they're right. Maybe women are lying 2/3 of the time about abuse. If you believe that, as the fathers' rights advocates do, then there's no problem in the courts. Everything's fine. If you don't believe that, as most objective professionals don't, then there's a problem. The other important limitation is that because we were using this electronic search to find the cases, and the case, by the word case, I mean judicial opinions, we were using published opinions as our data source. In order to get that electronic data, which was the only way to do a national study, most of them are the appealed cases. Most trial court opinions are not published, or even at all, let alone published online. And so most of these are cases that were appealed, and that could make a difference. It could be systematically different what's going on in those cases from what's going on in trial cases that don't get appealed. We did a little comparison because, to our surprise, we did get roughly 400 or 500 cases which were not appealed cases. They were trial court opinions that went online, to our surprise. They were mostly a few states. And we found, when we did that comparison, that there were fewer custody losses of mothers in those cases that didn't go to appeal. But the gender differences and the rates of disbelief of abuse were not significantly different in the cases that didn't go to appeal. To us, that makes total sense because it's much more likely to have appeals when people lose custody. So in the cases where they're not losing custody, they're less likely to go to appeal, so you're going to have higher rates of custody losses among the cases that are appeals. Now I think I'm going to take a break.
All right. We're going to have a brief break for Professor Meier. I'm going to go now, I think, to Alexis Moody rather than have some questions and comments for Professor Meier, because I'm going to let her have a sip of her tea, get her cough a little bit better, and we're going to go to Alexis Moody, who is going to talk a little bit about the family court here locally. And thank you so much, Alexis. And if we could go to Alexis's slides, that would be great.
Good morning. Thank you for having me. Wait for my slides. My name is Alexis Moody. I am the directing attorney at Legal Advocates for Children and Youth. I'm going to I have a lot of information in my slides, and I'm going to kind of try to narrow down the focus from what I've included, but I did want to just go over some of the more kind of procedural aspects of dealing with child abuse allegations in family court. Thank you. Actually, we go back one slide. I just wanted to orient everyone that these are the general court systems that consider child abuse allegations. And in each system, they're looking at child abuse allegations for different reasons. And so, go to the next slide. In family, the reason is generally to determine who should have custody of the child. So this is not a punitive court. There's not criminal allegations. The higher question is a custody question, and allegations of child abuse are presentations of facts in order to determine who of the parents sitting before you should have custody. And there are potentially many facts to help the judge to make that determination, and allegations of child abuse are one of them. So litigants, the majority of litigants are just two parents and are self-represented. So the minority of people participating in family court are people with paid attorneys. There is no right to appointed counsel in family court. We'll talk a little bit about minors counsel towards the end of the presentation, but the majority of people who are utilizing the family court system do not have representation. and are not entitled to any representation. Most people coming there are there for a broader reason: a petition for dissolution, they're trying to get divorced; a petition to establish a parental relationship, which is saying, you know, this person here who I was not married to is the other parent in this case, and I'd like child support. I need to divide my assets. I need other orders related to the children in the case. And then requests for domestic violence restraining order as well. Next slide. So here are just some common scenarios of why people may be making child abuse allegations. They come up both as the kind of presenting issue for people coming into court, but also come up in cases where people have ongoing litigation. Next slide, please. And then just some general information about how a parent brings a child abuse allegation to family court. It's presented in the format of a request for order, asking for child custody and visitation orders, and then, as I said before, alleging child abuse are the reasons for their request. That can be done on an emergency ex parte basis without notice to the other parent. The judge reviews the facts in the pleadings, and if it meets the threshold, can make temporary orders granting one parent emergency custody over the other. And then these allegations can also be addressed in a request for domestic violence restraining order. A parent can file a DVRO request on behalf of themselves and child as protected party, even if the abuse was only perpetrated against the child. Next slide, please. The next couple of slides are just the family code. I wanted everyone to have this. Just these are the family code sections that govern child abuse in family court. I'm not going to read them, but you'll have them. So what happens next? If the judge gets an allegation of child abuse, the judge has a few options. They can refer the parties to an emergency screening with Family Court Services, and luckily you have someone here who used to be with Family Court Services who can address that, so I'm not going to go too far into it. But just to take a step back, if the judge is taking any of these options, it's because the allegations before them either require significant more investigation, or the judge has a credible concern that neither parent is a safe option. So if, and I'll talk about this in a moment, the judge felt that they have enough information to make an order regarding custody of one parent over the other, they would not necessarily need any of these additional options. But these are the things the judge can do to continue investigating child abuse if they have a concern that either they don't believe the allegations of either parent, or they need more information, or they are concerned that neither parent is a safe custodian of the child. Okay, so the judge can call the child abuse hotline themselves, and the judge can order an investigation pursuant to Family Code Section 3027. Let's go on. So an emergency screening, just going to buzz through this, is a quick screening conducted by, a quick investigation conducted by Family Court Services. I'm going to let Brenda talk more about this, so let's keep going. So the judge also has the protocol to themselves call the child abuse hotline. The judge, DFCS, the Department of Family and Children Services, will determine if the allegation based on the facts being alleged requires a 2-hour or a 10-day response. That's a pretty broad spectrum there. So it depends on what the allegations are, how quickly the Department of Family and Children Services is going to be looking at that case. Next slide. The judge can also request that the Department of Family and Children Services investigate pursuant to Family Code Section 3027, which is a longer period of investigation. Essentially, Department of Family and Children Services then has to provide a written summary within 18 days of the referral. giving the judge more information about the allegations. Or, as I had said before, the court can conduct a hearing and receive testimony from the parties and witnesses to determine if allegations are true and then make orders accordingly. And I think many of the allegations are heard that way when you are alleging domestic violence. The majority of custody orders, I would say, in my experience, coming out of a domestic violence hearing are based on the testimony of the parties and the judge making a determination of fact from hearing testimony. So I want to switch gears a little bit and talk about Lacey's work in family court. I've been with Lacey for 8 years total, and I started as a staff attorney taking court-appointed minors counsel cases and representing children and young adults in their own cases as parents. We also represent children in the probate guardianship system as well. As court-appointed minors counsel, this is an overview. The court can appoint minors counsel if it's in a child's best interest in a family case. The attorneys appointed are majority on they're majority from the private bar, just family law attorneys who meet statutorily defined requirements to represent children. So they have a number of kinds of cases that they have to have taken, and then they also have to do a number of hours of training in really specific areas, including early childhood development, child abuse, domestic violence, and a couple other, we'll lose it like Joe. Excuse me. A couple other areas. A couple other things about minors counsel, just because I know that has been a topic that's brought to you all before. My office, Lacey, is on the list for appointment, but we, like everyone else, consider our ability to take a case when we are called. There are approximately 40 attorneys on the the list of approved people to be appointed as minors counsel. Minors counsel is, we don't use the GAL system here, as the professor was stating. We have attorneys appointed for children, and we are appointed to represent both a child's best interests and then, if age appropriate, their stated interests as well. We have to share with the court that dual role of information. And attorneys for minors owe the child a duty of confidentiality. So an attorney for a minor is not a mandated reporter. If a child who you are representing in the role of counsel discloses child abuse to you, it is up to the attorney to work with the child to determine how best to share those allegations if they want to. Because ultimately, you owe the child a duty of confidentiality, and the attorney cannot share that information over the child's wishes. So just wanted to put that out there, that if minors counsel is attached to the case and is representing the child, they are the attorney for the child and owe that child all of the same rights and responsibilities that they would to an adult client. And then just additionally, that we also, at Lacey, bring cases on behalf of pregnant and parenting youth up to the age of 25 in their own family law cases. So our team's experienced in both representing children directly and then working with parents who are bringing their own allegations of child abuse in this forum against another parent. And that is what I have for you all today. All
right, thank you so much, Alexis. Actually, here's what we're going to do. We're going to hear next from Brenda, and then I'm going to open it up to questions and comments for any of the three of the panelists or about the topic in general from the members. So, Brenda Farrell, if you could come up, and thank you so much, Alexis, and please stick around. Brenda, as Alexis mentioned, is a former superstar with Family Court Services and now a superstar in her own practice. And I really appreciate you coming today to talk a little bit about the mediation and emergency screening procedures at Family Court, which other speakers have touched on a little bit.
Thank you. Can you hear me okay, or do
We
you
can
want me
hear
to
you
hold
great.
this? Okay.
Don't need to hold it.
Again, my name is Brenda Farrell, and I worked at Family Court Services for about 20 years, and when I ended my career there, I was a supervisor, so I had an opportunity to work in dependency court and also in probate court. And I felt like my understanding that I was tasked with was talk a little bit about how child abuse allegations may come to the attention of Family Court Services, maybe prior to even being brought up with the judges. So we do have a mediation process, which is usually typically the first step for families. When they come to family court, they file something and are referred to mediation. Mediation is a confidential process, but although we are all mandated reporters, meaning that we would have to make child abuse reports, elder abuse, or if I was in fear of you hurting yourself or somebody else. Should I move farther away? No, I don't. I'm just very electric, I guess. Anyway, so certainly if child abuse allegations come up, we are mandated reporters. We're not in the position of making any evaluations as a mediator. If somebody says there's child abuse, we do make a report. Even if somebody says, I've already made this report, we may develop the procedure that we were going to make the reports anyway, just to be safe. Also, if we have particular concerns, we can also, at the mediation process, ask that an attorney be appointed for the minor. The other thing that family court does is emergency screenings or investigations. In family court services, if there is deemed an emergency and the judge orders an emergency screening, then family court services moves forward with that. At that point in time, there may be allegations of child abuse that either have been reported or not. Again, our procedure had been that unless we have actually documentation that we can see that it was actually a report, we will also make a report if there's allegations of child abuse. In addition, we can also ask for a 3027 referral to the Department of Family and Children Services. It's not something that we can order as an emergency screener. It's ultimately up to the judge, whatever the judge orders, but we can certainly make that recommendation for the DFCS to conduct an investigation and have a report back to the court in 18 days. Also, as in mediation, as an emergency screener, I can request minors counsel if I have concerns about child abuse, and I think it would be beneficial to have somebody representing the child. So that was all I have.
All right, thank you so much. What we're going to do next is I'm going to open it up to questions and comments from the membership for any of our presenters or just in general. And I'm going to start us off with just a thought from myself based on my experience working in criminal prosecution of child abuse cases for more than 20 years, is that it often happens in my experience when I'm hearing about a case involving a child abuse allegation that someone involved in the investigation or in the case itself will say, and there's a custody dispute involved in this case. And what they could mean is that our jurors are going to be biased, possibly, against the facts of the abuse because they're going to be worried that there is manipulation or undue influence of the child. But it also could reflect the bias of the people involved in the investigations themselves, that they might feel that, well, if there's a custody dispute involved, that issues of child abuse should be viewed with more skepticism than other kinds of areas. So I'll just say that that's been my experience and something that is something that I think we all have to figure out ways within all of our agencies to combat as I think, a practical reality of how things operate on the ground. So I'm going to go first to Member Liu, who raised her hand, and then we'll go to other questions and comments. Yeah, go ahead.
I have a general foundational question. How are judges in family court appointed?
All right, so judges in family court are Superior Court judges, just like all other judges, and that means that if a seat opens up before the sitting judge has their term expired, then the governor will appoint a replacement. And if a seat opens up at the time of the expiration of the sitting judge's term than you have an election. So we have an experience of both just in the last month. So we had a judge here in our county whose term expired, and that at the end of the term, and it went to an election, so there was a vote about who should fill that seat. And we had 2 other spots where the judge retired before their term was over, and the governor appointed replacements for those judges. So just in the last month, we have 3 new judges who were selected, 1 by election, 2 by governor appointment. All right, go ahead.
Thank you. I have a lot of questions, so you can circle back with me after.
Okay, we'll start with 1.
Right. So first of all, Professor Meier, I'm a big fan. Thank you so much for your presentation. Given the high rates of rejection of mother's abuse claims, especially in child abuse, as you presented here in family court, what steps do you think, in your opinion, can be taken to ensure a more thorough and unbiased assessment of such allegations?
Thanks for the question. There's no magic bullet here. So I do think training is part of the answer. But what James just described as the kind of the prejudice against abuse claims when there's custody litigation is permeating every system, including the family court itself. And how you undo that prejudice is sort of like saying, how do you undo misogyny? How do you undo racism? It's pretty deep stuff. But I think trainings, requiring judges to hear from survivors like you all just did, I think they need to hear from a lot of people like that young woman. Data, I hope my data can help persuade some judges and system personnel that there's a problem here. I have come to the conclusion over the years that there needs to be a movement, a political movement. It needs to become unpopular to not believe women and children. Because right now it's really popular to believe fathers and to reward fathers. There's a strong cultural or ideological commitment to increasing fathering in our culture through the courts. And when fathers show up and fight for custody, there's a sense that we've got to reward that. That's a good father who's there fighting for custody. And there's a desire to not believe that they might be a danger. That's a very cultural, kind of ideological kind of circumstance and context into which women are coming with their abuse claims. So, and I think it's sort of a political value norm, like fathers are good, fathering is good, let's protect it and maximize it, versus there are a lot of dangerous guys out there. There are some dangerous women, but it's mostly men in these cases, and our priority needs to be the children. How do we create that priority in a real sense? I'm not sure. I mean, I'd like us to screen judges better too. I think a lot of people think family court's a dumping ground and it's where you start off and then you move on to something better. It isn't taken seriously in the judicial system. It isn't taken seriously generally. We could be much more selective about family court, and we could have intensive requirements in terms of training. And my understanding is that while California adopted Peque's law, it requires the training to be developed, but it doesn't require judges to take it. And in my experience, judges are very resistant. In fact, there have been judges, and I think California was one of the states, who oppose training on abuse. Like, they're outraged by it. And that, to me, is a problematic sign, if you have judges and courts believing that training is an affront to their authority. I don't know how you change all of that, but I think more authoritative voices speaking out more loudly. Your counsel could, I think, use its voice in a very effective way in that regard, but obviously you need to tread carefully in terms of how you can work with the court and not make an enemy of the court, but how can you try to lead change, at least in Santa Clara, and maybe become a model for others? I'm sorry I don't have a simple answer.
Thank you.
Thank you. I'm going to go to Member Stewart, and then we'll go to hands on my left as well. So go ahead, Member Stewart.
Couple questions. One, I believe, I'm sorry, your name? Miss Alexis. You highlighted that most folks have they self-represent in court, and then they're not entitled What does that mean, and why would a family not be entitled to representation in court?
So,
Alexis, if you could actually go back to the podium because the microphone will pick you up better there. Great.
So under the law, not everyone is entitled to court-appointed counsel. Only in our county, folks in criminal court are entitled to court-appointed counsel, and parents in our dependency system are entitled to court-appointed counsel. It depends essentially on what rights are potentially going to be infringed, whether or not you're entitled to court-appointed counsel. And so in family court, there is no free court-appointed counsel.
Yeah, I think that's the operative term there is free. So everyone is allowed to have an attorney. It's that in family court, there's not free legal representation, unlike in dependency court or criminal court.
Okay.
If I could just add a comment to that, it's because you get representation when the state is moving against you. You don't get representation when it's a private lawsuit, which custody is.
Thank you for that clarification. Why, and as far as being a Lacey, when you're talking about the Lacey attorney, doesn't have to report confidentiality. They're not a mandated reporter because they're there to fully represent, if I understood that correct. Can you clarify the why? Why not?
No attorney. So the basis of having an attorney is that you can form a confidential relationship with your attorney in any area of law. Anyone who has counsel has a right under the Code of Ethics to a confidential relationship with their attorney, and that is the same for children. So as an attorney representing a child, I hold the same duties of ethical duties and the duty of confidentiality to the child as I do any other client as a practicing attorney.
Okay, go ahead.
Just in real life how this plays out. So if you were representing a child and the child tells you, I'm being physically abused by one of my parents, and you say, that's terrible, I'm so glad you told me, I'd like to let the court know, or I'd like to report this to the police, or I'd like to report this to the Department of Family and Children's Services, and the child says, no, please don't do that. It's that no, please don't do that that you have to follow because you have that relationship with the child.
Right, and of course that would not be the end of the conversation. If I was representing a child who disclosed child abuse allegations, I would then be working with the child to try to get permission to tell a trusted person who I think could intervene, who might be a mandated reporter, who might be able to notify someone else. I'm not the right person to disclose if the goal is to initiate another investigation. But I am the right person to have a conversation with about what the next steps could be and to talk a child through why they aren't interested in telling, why they don't want me to tell anyone else. What are you worried about? What are you afraid will happen next? And what protections can I help create so that you could safely disclose or give me permission to disclose? So that isn't the end, obviously, of the analysis. I just wanted to clarify that if a child consistently says, no, you can't tell anyone, it is the attorney's duty not to tell anyone.
Lydia, I'm going to come to you in a second. I've got some other people hands, so we'll go here, and then I'll go to you.
Just a clarification on that one point, and she clarified it. So you have the responsibility to the child not to disclose if the child says, no, 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 you're not going to disclose it.
That is absolutely correct. I owe the child a duty of confidentiality. However, anyone who's trained to represent children in family court cases is going to be, doesn't want a child to be in their home being abused, is going to be looking for ways to take protective action within the confines of this confidentiality. It's a real bind.
Okay.
Yeah. Okay. I think it was Steve first. Okay, go ahead, Steve.
Alexis, I think it's important. You didn't get a chance to go over the law, which would have probably answered this, but Is detriment the criteria that I need as a grandparent to get my guardianship of my kids away from parents who have custody? Is that the criteria?
Detriment is the criteria to remove custody of any parent, for whoever's asking. In order to grant custody to a non-parent in family court, the burden is detriment. You must prove that it'd be detrimental to the child for both parents to have custody of the child.
So that's a very high threshold, correct?
It is indeed.
What two issues cited in the best interest of children in the family code are designated to be detrimental for children? Child abuse and domestic violence, correct?
Of course, yes.
So if you have a finding of either one of those or both of those, there should be an indication that the parent who is not being abusive or committing domestic violence gets custody. Is that accurate?
Yes.
Do you find that judges are following that most of the time or all of the time? Sorry to put you on the spot, Alexis.
I mean, you're asking my opinion, and I was only asked to present about the nuts and bolts of child abuse allegations. I mean, the court doesn't use the term detriment in that way, and I think that there is for sure an underlying goal of, if two parents are standing before me, I'm going to try to figure out how to make two parents have some participation in this child's life. And so I think that's the baseline.
Okay, but I want to make clear that the only two issues, including substance abuse, including everything else, that are defined as detrimental in the family code are child abuse and domestic violence.
I would agree with that.
Yeah.
All right.
Thank you.
Thanks, Steve. Brina, were you next?
Good morning, Ms. Alexis. Quick question. For emergency screening, you said, thank you, Ms. Brenda, that the courts are, when judges order emergency screening, they've already decided as a fact that both parents are unfit. That's why it gets emergency screening request from the judge?
Typically, according to our guidelines, is that if the judge has concerns about both parents and an emergency screening is ordered, if they're able to determine that the child is safe with one parent, then they would grant custody to that parent who is safe.
So with what data is that judge moving forward with that determination? Because my understanding is emergency screening is where judge is seeing these allegations, hearsay, he said, she said. Then we have an emergency screening. From there, the investigator looks into it and then goes back with the finding and says, okay, one parent is fit, the other is not, and there is some merit to what parents are saying, that yes, the child is being abused. But I guess where I'm getting hung up is the emergency screening. The judge has already determined both parents are unfit. So it's like you start there and then you go work backwards, but here I'm hearing the judge has made that determination.
So I'm sorry if I misspoke. I don't think they've determined that both parents are unfit, but they have concerns about both parents.
Okay. And then if through the interview process, the emergency screener goes through, interviews all the folks involved, their finding is, what if they do find that there's one parent that's unfit and not the other, and they've talked to the child's therapist? How much weight does the child's therapist play, who have seen patterns, who've worked with this family and has concerns? Is that trumped?
So as a screener and have done screenings, I weigh everything, and certainly a child's therapist who's maybe had a longevity with the child understands the system would be weighed pretty heavily. We have to weigh kind of all the documents. We do have access to CPS records as an emergency screener, so we would look at the CPS history. We would weigh in from the therapist, from the child, him or herself, and also including, teachers, things like that, doctors. So we would take kind of the whole thing, but certainly a therapist would weigh into it.
And then last question, sorry. What happens when the evidence is overwhelmingly saying, including child's therapists, the teachers, the school, that there is a concern with one parent, and then the screening comes with the different recommendation, it almost feels like sometimes the parent attorney that's more forceful or more carries weight usually gets that, it gets sided towards that parent. That's been my experience in my private practice. The more the attorney is making noise, is more powerful, it seems to walk away with that parent getting majority when the parent could be the one that's unfit.
I'm not sure how to answer that question. Again, I can only speak to my own experience, but as a screener, I'm going to, weigh and maybe it does take experience to know that you're not want to get caught into the stories. I mean, when you hear, one attorney saying strong things and another attorney saying strong things, you can be listening and like, okay, I really believe this, I really believe, but then you have to take all the data. And so that's what I see as an important role of the emergency screener, is to take that step back and take all the data and not get caught into kind of all these bells and whistles.
Thank you.
Brenda, I think that this goes to a broader point that Professor Meier was making, is that how important and how influential in the system the emergency screening and mediation process is, because the judges are referring to family court services and trying to get information that they don't have the time to do, and then whatever comes out of that then becomes an incredibly influential part of what the ongoing decisions are going to be.
I would say so, but again, in Santa Clara County, mediations are confidential, so the only thing we provide to the judge is the agreement and areas that they're disagreeing. Again, in cases we would make a child abuse report, or if we really feel like there's some major issues, we would ask for an attorney for the minor, which obviously would be a huge red flag for the judge that something's going on.
Right, and sometimes even ask that a therapist be appointed if there's not a therapist. Or recommend that.
Yes, we can recommend that, yes.
Yeah.
If the judge would go along with that, yes.
All right, I'm going to go to Greg, and then I'll go to Kathleen. So Greg first. Oh, I'm sorry, and I forgot Dr. Sturm. We'll go Greg, Dr. Sturm, Kathleen. Go ahead.
Thank you, James. For Dr. Meier, a simple question, maybe a big answer. I saw domestic violence and physical abuse, sexual abuse wrapped up into your data. Was there any allowance for psychological abuse, or was that included within the data? Because that's where I see a lot of the challenges, is especially in a custody battle, is you've got one or the other, kind of intimidating, creating fear, psychologically damaging the child, and it may not involve some type of a sexual or a physical action, but it's just as damning as anything else.
Thank you for that question. We actually wanted to do psychological abuse, but there was even the state laws that we're familiar with, by and large, don't define it. And anybody can accuse anybody of being mean or whatever. I mean, I'm not minimizing. I know how severe psychological maltreatment can be. But no, we were not able to code for that because there was just no objective measure of it, and courts didn't discuss it in any objective way. I mean, they almost didn't discuss it at all, to be honest. What I find is that the courts are hard-pressed to even take domestic violence seriously. So if you're talking about something that isn't violent, they're even less likely to take it seriously, even though I think we know, or certainly you probably all know, that psychological maltreatment can be far more damaging even than violence. But there's not an objective definition. There's not an objective definition in state statutes, and I don't see courts addressing it. When it comes to terrorizing, though, that's usually part and parcel of a battering or abusive pattern, and it may be part of coercive control, which is why and I think California has adopted coercive control for consideration, right, in custody.
In family court, yes.
So it may be that what you're calling psychological abuse in many cases may fit within the definition of coercive control and be brought up that way, but that's so new, generally, everywhere, that it was definitely not in our day. We actually did code for coercive control, and we got a handful of cases, which we still have not analyzed yet. So, but by and large, it's just not, I'm sorry that our study doesn't shed light on that.
Thank you. And then one quick one for our Lacey representative over here, and hopefully a quick one. What are the qualifications for someone to get to receive help from Lacey? And I ask that because while sitting on the commission here, the council, you see folks from all over the county that have had challenges. And today when I hear the person with the attorney and the person without the attorney, I'm not sure it's really an income-based type of a thing. A lot of people need help. I know you can't help everybody. On the other hand, there's a lot more people that need help that may not meet a minimum income threshold too, and it seems like they're getting left behind.
So a private citizen cannot come to us and retain us to be court-appointed minors counsel. Only the court can appoint us. In order to be represented in their own capacity in a family court case, they need to qualify as a survivor of crime. Our funding is through the Victims of Crime Act, and younger than 25. That in those cases, we could help a youth or young adult in their own family court case as parents, or if they're seeking domestic violence restraining orders.
So only children that are in a court and have an attorney appointed by the court, they're the only ones that have access to the attorney?
If the court appoints an attorney for the minor if it's a minor who's in a family court case, only the judge can make a decision about whether or not that child should have an attorney. And then they go to a list of attorneys available for appointment.
Okay, thank you.
Dr. Sturm, go ahead.
Is this working? Oh, very good. So I'm the medical director of the Children's Advocacy Center. We haven't talked at all about medical assessments and how that pertains to the court process. As you all probably know, we receive referrals from law enforcement and DFCS across Santa Clara County. I obviously am speaking as an advocate for the CAC, and I own that. But I do think that we're in a slightly better place than many counties because our CAC has become such an important nexus for the care of children who've survived abuse and neglect in our county. Just to have some numbers, because numbers are very helpful. When we opened the CAC, we were seeing about 200 cases a year, very round numbers, 100 cases sexual abuse, 100 cases of physical abuse and neglect. This year, for the first time, we're going to hit 500. So that's more than double what we were seeing before we opened, which is not a reflection of more child abuse in our county. It's a reflection of the increased connectivity of DFCS, law enforcement, the DA's office, and the CAC. So I know that our reports are important because I regularly receive requests from social workers saying, can we have your report next week? We have a court date. So that's...
Right. And they're probably referring to court dependency. Okay. They're probably referring to dependency court dates.
So that is very important information. I also want to say that it is a little bit of a black box to me about how our reports are viewed in family court, and I think that one of my takeaways from our meeting today is that, I'll talk to you about it afterwards, but maybe we should have a sit down with the judges and make sure that we are providing them with the information that they need and, in the interest of transparency. The last comment I want to make very specifically about something that was mentioned earlier today is what happens when we have, I don't want this to sound snarky, but frequent flyers at the CAC. What happens when we have a parent who makes multiple allegations to DFCS or law enforcement about the other parent and end up in our clinic multiple times? So I just want you all to know that that doesn't happen very often, right? It happens much less often than you would think, maybe 2 or 3 or 4 times a year, right? And when it does happen, we take it very seriously. First of all, we take it very seriously because it is a red flag that perhaps the child is experiencing egregious abuse and it is not rising to the level of attention that it needs to rise to. On the other hand, if we do feel that for whatever reason, one of the parents is working the system to try to get the care that their child needs, we will talk to their social worker, gently talk to the parent, and explain to them that there are consequences for allegations when they're not substantiated. So I just want you to know it doesn't happen very much. Most of the time when parents bring concerns to us, they're truly legitimate. You know, they range from legitimate to heartbreaking, and we do our very, very best to have a very authentic, profound relationship with DFCS in the support of children. And again, I do have the experience of working with social workers in other counties, and I don't want to be Pollyannish in any way, but honest to goodness, we have the best DFCS of any county that I work with around us. So there's always lots of room for improvement, and I see that all the time. But our line social workers, our emergency response social workers are so thoughtful and intuitive and hardworking and smart. And I'm just always very proud to work with DFCS.
Thank you, Dr. Sturm. Member King?
I have a question for Professor Meier, but she put her hand up too, so.
All right, she'll get to your question, and then also, do you have a comment first, Professor Meier?
Yeah, I did for the last speaker. It's thrilling to hear from you and about your CAC, and one of the things that I've dabbled in but not taken very far is to try to start linking CACs to family courts, because they're not. They're linked to DCFS and criminal court. And the social workers you're dealing with are not in family court. And so there's two issues. One is institutionally for CACs to expand their remit, which could be substantial. But the other is for family courts to be willing to hear from them. And I've seen family courts, at least where I am, reject testimony by forensic interviewers at CACs. They're not always receptive. But anyway, I think it would be fantastic and a wonderful model for the country if your CAC is able to build links to the family court and develop some mutual interest in your ability to inform them about child abuse cases. I think that could be, I've been wondering forever why that isn't the norm, and it's because systemically it's just not how things have evolved. But it would be fabulous if you could do it.
So one other thing that I meant to mention, which is really, really important. Y'all are very aware of the ACEs study and ACEs, really important work in ACEs. So we do the very best we can at CAC when we write reports to try to provide data, right? Like evidence-based medicine, referrals to the child abuse literature. We are not flying by the seat of our pants. We are not providing personal opinions, right? We are doing our very best to provide scientifically based, serious opinions. Another thing that we do for kids who've experienced multiple forms of maltreatment is we talk about their ACE score, because that is a way of linking emotional abuse, which you mentioned, to something quantifiable. We know that children who have an ACE score of more than 4 are at lifetime risk of everything ranging from heart disease to asthma to suicidality, chronic depression, PTSD, you name it. So we talk about that in our reports as a way of reminding people this is not a single occurrence, this is multiple forms of abuse. This child's the experience of domestic violence and emotional abuse, as well as physical abuse and sexual abuse, will have a long-term impact on this child's physical health and well-being, and must be addressed.
Thanks, Dr. Sturm. I know we're at 9 o'clock, but we do have 2 other question comments, so I'm going to ask people to hang with us for a few more minutes while we can get those last questions and comments. So, Member King, you had a question or a comment?
Yes, it was for Professor Meier. One, I think the the testimonials are very helpful, but data along with it makes it both very helpful. And I can't get your 2.8% less likely to believed to work with your ratios later in your presentation. It just seems like the amount of mothers claim child abuse, they are 2.8% less likely to be believed, is a very small percentage. Your ratios.
No. Oh, okay. I think
Is it 280%? 2.8?
No. It's not they're 2.8% less likely. The odds are that they are 2.8 times less likely to be believed. So almost 3 times less likely to be believed. That's not say.
Yeah, I would suggest you change that slide because it didn't make sense to me. But
I understand it can be confusing. I've been forced to use that language because statistical analysis requires it to be said that way. If I said it in the terms you're talking about, it would not be statistically supported. So I have to talk, it's like a probability.
Yeah.
What are the odds that you're going to get hit by a car today? Hopefully 1 in 10,000, right? But if the odds for you are 3 times what the odds are for somebody else, that's significant.
Yeah.
That's what we're talking
So
about.
what I would read that as 280% less likely to be believed, but that's, maybe I do data a little different, so I don't.
I'll think about that. I'm not a statistician, and maybe you are. I'll talk to my statistical guy.
Yeah, I do a lot of data. And then along with that, it would be great if we could do some kind of study like that in our county, because I do believe data really matters, and maybe, some of our funding in the future could be used to analyze our own data.
Such a great suggestion.
I can also share the California cases from our study. They're back in 2005 to 2015, but I could share those and our statistics on those if that's useful to you.
That would be great, Professor Meier. So if you can send me that, I'll make sure it gets sent out to all the members. Thanks.
Thank you, Professor Meier.
My pleasure.
Member Stewart?
Yes, Dr. Meier. Curious about the racial breakdown with the mothers and the fathers. That probably might be a whole lot for right now to talk about. But any thoughts on that, just quick, and maybe I can communicate with.
I have a sad answer, which is that we couldn't code or analyze that because we were looking at court opinions and they didn't specify anyone's race. So, we have thousands of court opinions, but we have no idea what anyone's race is. Same with class, even representation. We weren't able to code for that because it was so inconsistent in terms of what was put in these opinions. So we don't have anything on that. We are working with a network of organizations that work with diverse populations. We've done roundtables with them to discuss these issues, but that's all impressionistic. It's not data-based.
Thank you.
All right, I'm going to go to last question, Angelica, because I said it was going to be a last question or comment, but I missed your hand, so I'm going to go, Angelica, last question.
Thank you, Chair, and apologies to the rest. I know we're a little bit over time. My big question was really more a systemic question, and anyone can answer this. But how can Family Court Services, specifically probably Brenda could answer, and DFCS better coordinate to prevent child abuse allegations from falling through the cracks, especially when parents are engaged in custody litigation? It would take a while, but so I just wanted to pose a systemic question.
Maybe an overall system thing is I think just better communication between Family Court Services and DFCS.
Could you stand at the podium? I know that it's weird to be talking but not facing the person you're talking to, but it'll pick you up better if you
if I face this
There
way.
you go.
Okay,
exactly.
got it. So systematically, it would be better for Family Court Services and Child Protective Services to be able to speak to one another. Now being in private practice, I would also hope that private practice evaluators and screeners would be able to also have better access to Child Protective Services. We can get an order requesting records, and at times it can take a while to get those in private practice. So that I think would be a systemic change.
I'm sure County Council loves that I asked this question.
Sorry.
All right, and I said that I was going to go back to Lydia, and I forgot to go back, so I'm sorry, Lydia. You'll have the last word.
Okay, mine is just a quick one. I'm following up on what Marlena said and also what Dr. Meier said. I think it might be worthwhile for us to think about asking the judges to come so that they can be part of our discussions and we can further let them know what we're about. They have contact with the families and the children especially, and not that we want to be trainers, but in a sense we want to let them know about all of this. And I bet you two would think that that would be a good thing to do to tie them in. I would like to explore that idea.
I think that's a great idea, Lydia, and we tried to get some family court judges to be here today, and that was not successful, but we're in ongoing communications with the family court to see how we can have that line of communication. All right, I really want to thank all the presenters, Professor Meier, from taking your time to be here all the way from DC, Brenda, Alexis, thank you so much, and so many public commenters today. Thank you very much. And we are adjourned.
Thank you. Happy holidays to you. Are you going to get a break?
I think it's because not so after the
All right, not so happy. Yeah.
Oh, thanks. Take a look. Look at this. Hi.
So you want to go down there?
Certified
Right?
Oh, God. Okay, this is good. Commencing over 10 years ago. Yeah. That sucks. That's not good. That's not.
Because sworn in.
Not enough money in it, huh? Pediatrics? Right.
You do not. We open the door for you. But there's this real.
There, so I'm just going to put you. Do you remember the time you came in?
That, like for example, our hospital is looking for somebody who's fellowship
Right.
to replace me.
Right.
I don't know how to find it.
Yeah.
Because this whole community, this is the Helper Society list. This whole community knows that
Yeah.
they're not going to come here.
Yeah. Okay. I got it.
They come here with every opportunity. Why would they come here?
That's not good.
Oh, you're trying to squeeze by. Yes. Great.
Gonna go home this weekend?
No, I was just in LA. I'm working this week.